Good morning. Happy Friday. So, I guess, what is his name? This is a public service something? I think his name's like Josh Gray. He's one of the people who Lane Myers isn't supposed to associate with. He posted a recording, an audio recording of the initial hearing for Lane Myers. It was pretty interesting. I mean, I did listen to a reporter's recounting of it, and I didn't think that Lane Myers was as obnoxious in it, you know, as was reported. One of the things that is going to come up probably in later in this video is the difference between lying and how people perceive information coming in. In being a lawyer, you deal with this a lot. People don't hear what is said. They hear how they interpret what was said. Generally speaking, they don't. And as a lawyer, you're very sensitive to this. Police probably are also sensitive to it. Listening to what is actually said and not how you interpret or feel about or understand what was said is a skill. You'll see it a lot as a lawyer. You see it a lot when you ask a very direct question, like, what date did this happen? And you get a completely different response. And you're like, okay, that's great. But what date did this happen? Again, a completely different response. I need you to listen to my question, and I need you to answer my question. What date did this happen? Oh, and then you get, so people, and it's not just how they feel about it or whatever. A lot of times people think that you're asking a different question than what you're actually asking. People, like, I was at court yesterday, and the bailiff asked me for my bar number, but he didn't say, can I get your bar number? He says, do you know your bar number? And I said, yes. And he looked at me like I was a retard, but I listened to what his question was and I answered his question. It's just that lawyer habit kicking in. I've told everybody my 5 rules of deposition before, but I'll tell it to you again. Whenever I'm defending a deposition, I instruct my client in these 5 simple rules. Number 1, wait 5 seconds before you answer any question. And part of the test is, I'm like, raise your right hand, repeat after me. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And they say yes. And then I say, wrong. You count to 5. It's 1, 1,000, 2, 1,000. In your head, you count slowly to 5, and then you say yes, because you want to be consistent in how you answer every single question. So you wait 5 seconds before you answer any questions. Rule number 2 is, while you're waiting those 5 seconds, you think, can I answer this question, yes or no? Is it a yes or no question? Do you know your birthday? Well, the answer to that question is probably going to be a yes or a no. I mean, most people probably do know their birthday, so they say yes. Most people answer that by giving their birthday. But if you can answer yes or no, you answer yes or no. The third rule is there's no question that opposing counsel can ask you that you can't answer in one question. If he asks you a compound question that you would need more than one question to answer, I will object to it. So there's no question that you can't answer in one sentence or less. It might be one word, might be 2 words, but it's not going to be more than a sentence. So take as long as you need, sit there and think about it until you can answer whatever question they asked you in one sentence or less. Rule number 4 is, if you don't know the answer, you say, I don't know. You don't guess, you say, I don't know. Do you know how much money I'm getting paid to represent opposing party on this? You don't know. You say, I don't know. You don't guess. You don't say probably a lot. You don't say anything like that. You say, I don't know. If you have an estimate, you can give an estimate, but here's the difference between a guess and an estimate. An estimate is how big do you think your kitchen table is? Well, you can give an estimate for that. You've seen your kitchen table. But if I ask you how big is my kitchen table, you'd have to say, I don't know, because you've never seen my kitchen table. You don't know. And then rule 5 is a very simple rule. Always tell the truth. There's nothing that is going to get you into more trouble than telling a lie. You might misremember something. You could qualify things with, I vaguely remember this or something like that, but never lie. Never lie. You might think that something's going to be horribly harmful to your case, but what is going to be worse for your case is lying, right? So those are my 5 rules. And people have a very hard time following those 5 rules. Very hard time. I have yet to have any client who has been able to successfully follow those 5 rules through a deposition. Usually they start off strong, but then opposing counsel says something that, irritates them, or their feelings about opposing party kick in, and, they blurt something out or whatever. And so what I'm saying is that lying isn't necessarily what's happening. People misunderstand, misinterpret, hear what they feel like you said instead of what you actually said. So accusing someone of lying is, generally speaking, something that I am hesitant to do. Even, I might say opposing parties lying because I'm trying to put a negative spin on them, but in my head, I'm thinking that probably they're just misremembering or misunderstanding or something like that. So I'm not saying the reporter lied, but that reporter is very much against Lane Myers, and so anything that Lane Myers does is going to be seen as worse than it may actually be. So I listened to this initial hearing. They did combine the arraignment with it just because everybody was there, and why not? So one of the interesting things to me was the prosecution said that there was a police report filed in Phoenix, that they're working on getting it, a copy of the police report, but they have Lane Myers on video making the call because he's dumb enough to live stream his crimes. And Lane Myers and his attorney both instantly knew that was the, something, Associated Council of Prosecutors or whatever. Anyway, so they instantly knew who filed the police report. That's usually a bad sign. If you know that your actions are likely to lead to a police report being filed while you're on probation, that's a bad sign, because you have to remember that the burden of proof on the state in a probation revocation hearing is a preponderance of the evidence. It's basically a 50-50 with a little bit extra. It is a relatively low bar. You went from beyond a reasonable doubt at the criminal stage to preponderance of the evidence at a probation revocation stage. Very low burden of proof. So if you're doing things that you know are going to generate police reports, or that you think generated a police report, because the prosecutor never identified who filed the police report, who the complaining alleged victim is, that's a bad sign. That's a bad sign. You already know you're pushing the line if you know who filed the police report. Bad sign. This does not bode well for Lane Myers. You can't commit crimes while you're on probation. And having a police report generated is not a good thing. I mean, it'd be worse if it turned into an arrest warrant. I mean, that's even worse. That means that there's at least probable cause, or there's probably probable cause. It's even worse if you're arrested on it and charged. I mean, that is a better indication of probable cause. But I mean, it's not good. It's not good. So apparently Lane's attorney is still elbow counsel for the motion, which is bad for Lane. I do think Lane has some reasonable arguments about maybe narrowing some of the probation conditions so that he could talk about public matters that the husband of the victim is involved in. But I don't think that technically he has to mention the husband of the victim to talk about those matters. So he's going to need to have a really good argument. And listening to his arguments in this initial hearing / arraignment, he doesn't have the arguments put together in his head. Like, you can't just ramble your way through it. You can't kind of bullshit your way through it. I get it that it works for his audience, but the judge is going to be looking for concise points. This case said X, Y, and Z. This case is analogous to my situation because of these factors. And so based on that, the conditions should be tightened, should be modified, whatever. They're overbroad, whatever the argument is. He's gonna really have to basically bullet point it out for the judge, because his motion did not. So he's got some homework ahead of him, unless he hands it over to Resnick, his attorney, his elbow counsel, to actually take over, which would be the smart move for Lane, which is precisely why he's not going to do it, because he likes to shoot himself in his own crotch. But I mean, I in the interest of justice and fairness and everything like that, I would really like it if Lane would hand it over to Resnick, because I think Resnick has a much better shot of making a coherent argument based on actual case law for modifying the conditions to allow Lane to do things like talk about these public issues, this proposal that's going to the Arizona Supreme Court. Now, as far as a First Amendment challenge to it, most cases, and I believe Arizona is one of these, looks at harassment, laws against harassment, as conduct-based restrictions. This is like burning a draft card. You know, the rule is you can't deface or alter or destroy your draft card. Someone does it as speech. They burn their draft card as speech. Well, you get a lower scrutiny level of review on it than you would on a law that prohibits speech as speech. So a conduct-based restriction gets a lower burden of proof. So harassment laws, generally speaking, have that lower level, and I've never seen a harassment law get overturned as being overly broad because they're restricting conduct. And that might catch speech, but it's still a conduct-based restriction. And the state has a high level of interest in preventing harassment. Unchecked harassment leads to violence. It leads to other things like, people getting upset to the point where they pull weapons or whatever. So the state has a very significant interest in preventing harassment, and by restricting certain forms of conduct, usually speaking, it has to be a pattern, more than one. People are going to blow up and go off on each other every once in a while and scream at each other and whatever. But if it's not a pattern, generally speaking, the harassment statutes won't catch them. Lane likes to do patterns of harassment. He gets it in his head and he can't let it go, and he chews on it like a dog chews on a bone until eventually he's built up a pattern of harassment. And a pattern, like in California, a pattern of harassment just means more than one incident. So it could be two. You could do this, you could do something twice, and all of a sudden it's a pattern. So there was a comment that a commenter left who says specifically that he supports Lane Myers, and he tried to excuse the guilty plea. He said, the witness is a liar. She's a corrupt government employee. The prosecutor is corrupt. And those three things right there. Let's go back to the witness is a liar thing. I've just talked to you previously in this video. Hopefully you have the capability of either remembering it or rewinding. But the role of an attorney is to cross-examine opposing parties' witnesses. That's the job. And the reason why you cross-examine them is to bring doubt onto their testimony, either to show that they're lying or they're misremembering, or that their testimony can't be trusted for some reason, right? That's the role of an attorney. By saying that the witness is lying, first of all, the witness hasn't actually been called as a witness yet, so that's a little bit premature. You don't know what she's going to testify on the stand. She hasn't been deposed. She hasn't as far as I'm aware, made any statements under penalty of perjury, and you might just not understand the statements that she's made. You might be misunderstanding the statements that she's made, because again, that whole thing about people interpreting things through their own emotions and feelings and understandings goes both ways. So it's not just the other person who does it. You also probably do it too. I've done it multiple times throughout my life, especially before I became an attorney. Less since I've become an attorney, but I still do it. Like in the comment section when I'm like tired or whatever, I have a screaming kid next to me. If I'm looking at a comment, I might misinterpret it, which is a lot of times why I'll just heart it and move along and come back to it later when I'm in a different headspace, so that I could actually look at it and read it and understand it. So you saying the witness is a liar, well, I mean, she hasn't been a witness yet. She hasn't been called to testify. That happens at trial. So she isn't a witness. And if she is a liar, either you're saying that Lane is incapable and understands he's incapable of cross-examining her effectively to show that she's lying, or you just don't understand the court process. So just saying that the witness is a liar does not justify a guilty plea. It doesn't. Like, that's the whole point of trial, is to challenge the evidence against you. If you just roll over and say, if she's going to testify this, well, I might as well just quit. That you don't understand the process, or you don't believe you're capable as an attorney to cross-examine them, or you're just a chicken shit. I mean, it's one of the three, right? Saying that the government employee is corrupt. Well, I mean, like in her position, like what did she do that's corrupt as a government employee? And this whole government employee thing is just really weird. Like, do you think that, do you understand there's a difference between like the janitor at the local high school and a governor? There's a difference between there. I think you could probably understand the difference. The governor makes decisions that really affects people's lives. It affects citizens' lives. His decisions directly affect the public, right? The janitors don't. Like, his decisions are like, do I clean the boys' room first or the girls' room first, right? Like, which toilet do I start at? Do I start at that end of the toilets, or do I start at that end of the toilets? Like, these decisions don't really affect the public. And so the body of law about public officials, generally relating to First Amendment issues, not harassment, not conduct, but like defamation and criticism, those laws understand there's a difference between people like governors, whose decisions directly affect the public, and just your average government employee whose decisions really don't. The clerk at the courthouse, their decisions affect me all the time. I have strong disagreements with them on a regular basis, but they're not public officials because their decisions don't really affect the public. Okay, you want me to change this on the sheet? Fine, I'll do it. Let's just get this filed, right? Is different than, for example, a judge who is a public official who makes rulings on all sorts of cases that directly affect the public. Police officers, while they are employees, so your average public official is going to be elected, generally speaking. People like police officers who are just employees are also considered to be public officials because they make decisions all the time that directly affect the public. Closing a road down for an accident, arresting someone. These are major decisions that directly affect the public. Prosecutors. So the victim's husband is a public official, probably because he's a city prosecutor. He decides what cases to file, what cases to pursue, what settlements to take, things that directly affect the public in a major way. Not minor things like which bathroom do I clean first, but in a major way. Which criminal do I go after? Alleged criminal do I go after? What settlement deals do I accept? The settlement deals that I accept may directly impact the safety of the public at large. You know, taking a settlement that a plea deal that gives someone just a minor misdemeanor when they could have been convicted potentially of a major felony, you know, that might put that person out there to reoffend sooner. That directly affects the public. That's a public official. And those are the people where you have increased protections for criticism and potentially defamation. That's where you get the whole reckless disregard of the truth or falsity, the New York Times standard for defamation. Speaking of which, what's that guy's name? For Public Safety. I know I'm kind of bouncing between topics, but these are related. Accused me twice of violating 2 rules of professional conduct, which implies that he's the interpreter of those rules, that he has some inherent knowledge of them. One of them is California Rule of Professional Conduct, Rule 3.6. That's identical to the one that Lane Myers tried to accuse me of doing. The difference between For Public Safety and Lane Myers is that Lane Myers actually read it on his stream and was like, technically it doesn't apply to him because he's not involved in the case or anything like that. So technically it doesn't apply to him, but he still should probably not talk about it. So at least Lane Myers figured out that it doesn't apply to me. Apparently For Public Safety is even stupider than Lane Myers, which is something that he should possibly be concerned about because he didn't realize it. And Arizona's Rule 3.6 and California's Rule 3.6 are both identical. They're both based on the American Bar Association Model Rules of Professional Conduct. And I think they're verbatim, word for word. At least if they're not, they're almost identical. In all important aspects for this analysis, they're identical. But the other one that For Public Safety accused me of is, I think it's 8.4 subsection D, interfering with justice, whatever. I forget the exact language of it. But what he failed to do is he failed to read the comments down below. And the comment specifically for subsection D is that this does not imply, this doesn't prevent a lawyer from exercising his First Amendment rights. And the only restriction on those First Amendment rights are things like true threats, which obviously aren't protected speech. And if you say some outrageous and defamatory thing about a judge, that is the, they have to apply the New York Times standard before it's a violation. So it has to be made with reckless disregard for the truth or falsity of the outrageous and defamatory thing. So obviously, and you know, I mean, just how many legal analysis, legal commentary channels are out there? You know, how many times has like Fox News, CNN, whatever, MSNBC brought in a legal expert like a retired judge or a lawyer or somebody like that to talk about an ongoing case, like the lawsuits with Donald Trump or the Supreme Court cases. You know, I mean, this is protected speech, so it's nonsense. So public officials have that increased protection, or you have increased protection criticizing public officials, but that doesn't apply to harassment. You can't do more to harass them. Again, harassment is a course of conduct. So the witness lying, you know, she hasn't been a witness. The public employee, you can't just harass a person because they're a public employee. I don't know how she was corrupt. She didn't do anything in her job that brought Lane Myers' ire. His ire with her was that she had the gall, the audacity to marry a guy who either was or became a city prosecutor who did something that Lane didn't like. So her public employee status is just a cope. It's just grasping at straws. It's like Lane Myers grasping at Rule of Professional Conduct 3.6 to come after me. It doesn't apply. It doesn't apply. Nothing applies. Just because she's a public employee is entirely irrelevant. The prosecutor, whether she's corrupt or not, I mean, I don't know that she is. I have no reason to believe that she is. She is prosecuting a case. If you can't identify an issue with that case, well, then her being corrupt or not, like, I think he's implying, the commenter was implying that like somehow she's taking a bribe or something to do this. I mean, show me the evidence. Show somebody the evidence. But even then, all you'll do is you'll get her off the case and you'll get another prosecutor in there who will still prosecute it. Because I hate to break this to you, but he is harassing, or at least he was harassing her. And then him pleading guilty, he did not plead guilty to get probation. I just want to be very clear about that. He pled guilty to 2 felonies, a level 5 and a level 6 felony, without any assurances that he'd get probation. There were 0 assurances. The victim argued for jail time. I believe the prosecutor argued for jail time. The judge decided to give probation But that was in a sentencing hearing. He pled guilty over here, no guarantees on whether or not he'd do jail. And then he lucked out and got probation, which awesome. I'm glad for him. I don't like anybody to go to prison. But he did not plead guilty to avoid prison time. He pled guilty. He pled guilty. He said, I did these things with no guarantees of any result other than the fact that he was only going to get sentenced on 2 felonies instead of potentially on, 6 or more felonies. And let's go back. He had a trial on the civil harassment. A court, I guess you could think that every judge is corrupt and whatever, but you can't prove every judge is corrupt, certainly. But the judge found, after listening to the testimony of both parties, that Lane Myers did in fact harass her, which means either Lane Myers is wrong about what harassment is, or Lane Myers is just really shit in court. Either way, it's a really bad sign for Lane Myers, and he should not be representing himself, and he shouldn't be making videos about the victim on YouTube, certainly. And one of the things the commenter said was, Lane Myers was kept in jail. He didn't have an opportunity to really prepare himself for trial. Well, let me also address that, because when he was arrested for continuing to violate the civil harassment restraining order, the injunction against harassment, he was given a PR bond. I guess you didn't remember that. He was given a PR bond. The court gave him an opportunity to go out there, dude, just keep your nose clean. You could be free until trial, right? And then we'll see whether or not you're found guilty. He was given a PR bond. And the first thing he did was go out and make videos harassing the victim. You retard. And then he had a bond revocation hearing. And the state proved to the judge at the bond revocation hearing that he violated the terms and conditions of his bond, that he went out there and started harassing the victim. And that brought more charges. He was free. He was free. His actions put him back into jail to await trial. So the fact that it was hard for him to do his own defense from jail, he shouldn't have fucked around and found out by violating the terms and conditions of his PR bond and catching additional charges. And he had a court-appointed attorney who could have done everything, who wasn't in jail waiting for trial. Lane Myers made his own bed. I keep telling people this, and I don't understand why they don't understand. Lane Myers is solely responsible for the position that Lane Myers is in. And the position that Lane Myers is in is worse than I think most people recognize. Because right now we're just doing a probation revocation hearing. The state can bring charges on these things. The state can bring charges for harassment. The state can bring charges for violating the current criminal harassment protective order, criminal protective order, whatever they call it in Arizona, because there is a lifetime protective order for the victim. There's a lifetime protective order for the victim that he is violating by doing this shit. Probably violating. In addition, I am reasonably certain that there's still an active civil protective restraining order, judgment against civil harassment, which he caught the initial charges for violating. There's so many ways to skin this cat. Lane Myers is in a heap of shit right now. Even if he wins on his probation modification motion to modify the terms of his probation, the state has so many ways to skin that cat. He's in a heap of trouble. I think kind of best case scenario for him at this point is that his probation just gets revoked and the state says, okay, fine. He's going to do 2 to 4 years or whatever in prison and be done with it. I mean, that's kind of best case scenario. He is just, someone gave that boy a bat and he's just beating the shit out of that hornet's nest. Anyway, I hope the supporters start to wake up. He's doing bad things for himself, and you thinking that he's right isn't helping him. You encouraging him, you egging him on, his friends egging him on isn't helping him. He's just getting deeper into a hole. And I hope he stops digging. Thanks for watching. Have a great day.